The next case to come before the court is Eaton Township v. KNG Limited. Each party will have 15 minutes to present their arguments. I understand that you are splitting time, correct?
That's correct, Your Honor. I'm Jim Taylor. We're going to take 9 minutes for K&G, and the village is going to take 6.
Okay, very well. And I'll let you manage that time, okay? And the appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded. Please keep your voices up and remain behind the podium. You should not use the names of children or minors or victims during your argument should that be applicable. And you can refer to people in that instance by their initials or generic terms. The judges have read your briefs and we're ready to proceed when you are. And Attorney Schrader, would you like to reserve time?
Yes, Your Honor. I would like to reserve 5 minutes if I might.
Okay, very well. You can proceed when you are ready. And if you would like, I can try to also give you a heads up at 9 minutes or so.
Yes, Your Honor.
Okay, very well. Ready when you are.
Well, may it please the court, good morning. I'm Attorney Al Schrader. I'm here on behalf of Eaton Township in this annexation matter. In annexations, the burden of proof is on the petitioners to show 6 items. From the outset, we said they showed the first 4. We're only arguing about 2. I'm going to begin, if I might, with what I think is the most simple of the arguments, and that is that they simply misread the statute with regard to segmentation of roads. Now, since 2002, the legislature noticed there have been problems with roads being divided. When that happens, people didn't know which jurisdiction to call. A lot of times, the jurisdiction didn't know who was supposed to go out and fill a pothole, plow a street, that kind of thing. So their solution was to pass an amendment that said when that occurred, that no street or highway will be divided or segmented by the boundary line between the township and the municipal corporation as to create a road maintenance problem, or if a street or highway will be so divided or segmented, the municipal corporation has agreed as a condition of annexation that it will assume the maintenance of that street or highway. Now, first off, there's no question that in this particular case, it created a road maintenance problem. You got an ordinance by the city authorizing the mayor to enter into some kind of agreement with regard to road maintenance for that very street. We also have an exhibit that I'll go into some detail on, which is a purported agreement for South Turkey Road between the county and the village of Grafton. Now here's the problem. First off, nobody did anything as a condition of annexation. In fact, they turned it on its head. Several times in the transcript, they referred to, well, we have this agreement, but the county isn't going to sign it, and we won't sign it until after the annexation is approved. At one point, I forget which the witness was, it was towards the end of the second hearing, they even said, well, the agreement is conditioned on the annexation. Now that's turning it around. The statute says the annexation is conditioned on the agreement to maintain. It would be like having a requirement that to work for the Court of Appeals, I have to have 5 years of experience as an attorney. But then that's your requirement. So it's conditioned on me having 5 years. And I go to you and say, hire me first and then I'll get the 5 years. That's the problem here. They totally ignored that section of the statute. And when they do that, your standard of review is de novo. So at the very least, we think this case should be remanded so they can apply the right statute. Here's the other problems with that. It says that if you do have a problem with road maintenance, and again, the actions of all the parties indicate they do, they recognize it, that's why they attempted to do anything here, they come up with this agreement, purported agreement, dated September 25, 2020. Now, in addition to it not saying anything about being conditioned on annexation, it also does not conform to the statute because Grafton never agreed to maintain the road. The basic road maintenance, plowing, that kind of thing, is up to the county. Grafton agrees to pay 1/2 of expensive road maintenance, such as repaving and that sort of thing. And the only thing Grafton's responsible for is if they require or want an improvement to the road that the county wouldn't normally put in, like curbs, then they agree to pay for that.
So you believe the statute requires the municipality to accept all responsibility for the road?
I
And
do, that's
nothing
what
for
it
the
says.
township or the, based upon the plain language of the statute?
Yeah, I'm sorry to interrupt.
That's okay.
Yes, I do, because that's what the statute says.
Ultimately, whether they had an agreement or not, if that agreement said, to the extent that agreement didn't say Grafton has to do it, it's violation of the statute. Grafton has to be the person who does all the work.
That is my view, because that's what the statute says. It doesn't say if there's a segmented road that causes a road maintenance problem, then the parties ought to get together and split who provides the maintenance. What it says is the annexing municipality, in this case Grafton, has to maintain it. And I know I'm getting a little old here. I've practiced law for 44 years now. But it's very disturbing to me when county commissioners and even trial courts tend to rewrite the law. I think that's a problem. And I don't believe that it's good judicial policy to simply totally read out words like condition of annexation. The legislature put that in there. It's got to mean something. The legislature put in that they have to maintain it, and they're not. So that's the first argument, and again, we believe on that one it's de novo. You ought to remand for them to apply the proper statute. We think they did the same thing with regard to the general good argument. And this is a little bit more interesting, I think, in the sense that since 2002, it's not just the general good of the area to be annexed. That was the old law. Now, the legislature requires that on balance, the benefits have to outweigh the detriments, not only to the area to be annexed, but also the township area within a quarter mile. Now, when you look at the April 6th, I think it was, the first hearing, again, they have the burden of proof to prove that. I don't. The township does not. We don't have to prove the negative. But their argument was entirely based on what was good for the developer, in their opinion. They had no mention of what the effect on the unincorporated area within a half a mile. Absolutely none. Then there's a 2-week break. At the second hearing, then they start talking about some of those items. No expert testimony, which I think is necessary in this kind of thing, where an expert looks at it and tells you whether the benefits outweigh the detriments. A planning expert, for example. None of that. At the second hearing, here's what they come up with as being a benefit to the township. 55 homes is going to add a little bit of money to the school tax base. We don't know how much. They never figured that one out. They just came up with that argument. The second,
There's some case law on that argument though, right? The Ninth District has said that that's a benefit.
I apologize, I can't hear.
The Ninth District has said that that's a benefit. That is where
They
school
argued-
districts get
Yeah,
money.
they argued that that was a benefit. I believe in the case, though, where it was found that that could be considered a benefit, there was at least a little bit of evidence as to how much or what the dollar amount might be. 55 homes may not generate all that much in terms of money. We don't know because they never told us. The second argument was it would create jobs, and I don't get that. If it were a business, it would create jobs. These are homes. So,
What about building the homes?
pardon?
What about building the homes?
That would create some jobs, but would those go to the unincorporated area within a half a mile? That issue was never addressed. And again, the burden of proof is on them. Here's the detriments. And I gotta back up a little bit. What the city said it would provide is water, sewer, and electric service, among other things. It's not in their water service district. They pointed that out in their ordinance. The sewer is provided by Lorco, which sent and had testimony from one of their representatives indicating, we're not giving this up. You're gonna have to fight us to change the sewer service area, which happens by a regional planning commission, which in this case is NOACA, not NEFCO, which is the one for Summit County, which I had first assumed it was. Whichever one it is, those changes don't happen unless people agree. So here's a detriment to the township, and that is, right now, it's in the Lorco service area, so the township has a voice before NEFCO. In fact, they appear to have a veto, according to the testimony of Mr. Gambita and others regarding those issues. If the annexation happens first, the township is no longer in any kind of ability to control who serves that unincorporated area of their township with sewer. That would be the village. So there's a real detriment, and it's more than just a theoretical political power detriment. The detriment is right now.
Attorney Schrader, I'm sorry to interrupt you, but I want you to know that you're heading into your rebuttal time.
Okay, well then I'll just finish with that thought. The other problem is, of course, right now, citizens within that quarter mile or half mile area know who's going to provide water service to them. If this changes, then you get that uncertainty. Is it going to be the village? Am I going to have to annex to get water? Is it still going to be Lorco? The other problem is, now you're going to have two sewer systems with all the pipes and all the expensive infrastructure in the same area right next to it. That makes no sense. It happens in Summit County, I recognize that, but that was 20 years ago. I think we've kind of moved away from that. So the point is, on both of these issues, number one, as I see it, they misinterpreted the statute because they really didn't pay any attention to the unincorporated area of the township as to general good. Again, de novo, you should reverse for and remand. I won't have time to get into the secondary argument, which is, even if you think I'm wrong on that, the balancing doesn't make sense. And I'm not asking you to substitute your judgment. So let me shut up and sit down and let the others speak. Thank you.
Thank you so much.
Good morning, Your Honors. Jim Taylor, I'm in here for KNG, who's one of the appellees. KNG is the property owner and the petitioner in the annexation, obviously. Since Mr. Schrader went backwards, I'll go backwards also and do the argument 3 and then come back to 1 and 2. First off, this is a segmented road. It's in the documentation. So there's only 1/10 of a mile of road here that's in question. Half the center line is the dividing line between the township and the village. So there had to be an agreement. I wasn't the initial trial attorney in this matter, or the administrative attorney, but there's a, we read through the documentation, there was a 1 mile piece, 0.1/10 of a mile piece segmented. They did do this, I don't believe the statute says you have to do it in front or behind, but they did in 2020 get an agreement signed by just the village with an ordinance and also a contract. But when you read the transcript on page 6 of the first day of testimony, Mr. Peter Zwick, who's our assistant county engineer in charge of all the real estate construction in the area, has been for quite a long time, he indicated in his testimony that there had been an agreement reached between the county, which is the document supplied and marked, I believe, as item 9 was the original letter from the county engineer saying that they were in agreement. And item 13 in the documentation was the road maintenance agreement. And Mr. Zwick then at the hearing testified that the county was in agreement with that documentation. They didn't sign it until after it went through, but that was taken care of. So I don't believe there's anything in the statute that says you have to do it beforehand or after. You just have to have it.
Well, does the statute say the municipal corporation itself has to provide the service rather than, in this case, contracting to the township?
Well, if it's segregated, we were only taking in half, so that's the problem. We were only taking in this annexation, half of the road was coming in, half of it was not. That's
Right, we have a segmented road, half owned by the township, I
Right.
take it, half owned by the municipality.
Right.
And what the statute seemed to say if we want some certainty into everybody, it's who's going to be doing this, at least the statute on the face of it says, evidence that the municipal corporation shall provide services. In this case, it's not providing services. I understand the agreement, the county.
Right, but when you can contract, again, there's the statute that the two entities contract, and that's what they did, and that's what they've agreed to, that's the argument we make at this point.
Does the statute permit them to enter that
It
agreement?
doesn't say either way. If I could do some homework on that, I could not find anything either way that says they could or they could not enter into the agreement that they did here. Okay. Going to the other two arguments, basically, the test. So basically, at the hearing, we're talking about the benefits to the land. There was, in the second day of testimony, as my colleague said, there was discussion about construction jobs that would come with that. The Midview School District could add, obviously, to its benefits. That whole area is served by the Midview Schools. Obviously, constructing houses adds to the tax base to the area. And so then they also spent a huge amount of time for 2 days dealing with all the utility issues. In most annexations that I've been involved in, I've done about 10, we have not made a deal with every service provider before the annexation because a lot of them were like, well, we're going to do what you're going to do or what's going to happen. But in this case, Lorco, which is the sewer, they acknowledge in their testimony, throughout the testimony, the first 100 pages, they have to put in about $500,000 to $1 million worth of infrastructure because they have to put in a pump, which they don't have. They don't have anything anywhere near this. Mr. Flanagan, this is a 4-phase subdivision. One fourth phase just happens to obviously be outside of the village. The other 3 were. They've already installed the pump system. They just have to run the lines, and it's approximately $1,200 in testimony to hook up to the system with the pump already there, versus the township is approximately $10,000 per hookup, and also made the development pretty much cost prohibitive according to Mr. Flanagan's testimony. Rural water, there was discussion, they deal with rural water on these annexations. They can do a variety of things. They can cede territory to each other. They can work out where rural water pays, we pay the village, I can't speak for the village, but through the developer would pay for that water or portions of that water with the contractual agreement. Again, this wasn't not all worked out. The statute just says you have to show you can provide services. Again, if you look at, I believe it's item 12, it's in the docket, that is the providing of services, police, fire, utilities, and all the requirements that the code requires. Police and fire, there was a great discussion about that, health, ambulance service, etc. So that was all weighed by the commissioners when they made their ruling. It was also reviewed by Judge Moraldi in the briefs with all the records he had, that he also had that ability. And again, it's a weighing test, I would agree. I don't believe this court substitutes its judgment for that weighing test unless it's unreasonable, arbitrary, or capricious, or the court didn't follow the law in its interpretation or its effect. So I believe, again, this court, I respect this court, but only if they find that Judge Moraldi and before that the commissioners acted improperly. They had lawyers, they had 2 days of hearings, everybody had a chance to put their statements in. There was no testimony against from the area other than from the township trustee who spoke and the various service providers. We did not have anybody come from the township and stand up and say word against this annexation. And again, this was a logical one because it built, Mr. Flanagan owned the land, just happened to have 1/4 of it outside, did phases 1, 2, 3, and then obviously it was stopped until he could do this annexation, which my prior counsel did. I believe the balancing test is met. I believe the preponderance of evidence shows that the good outweighed the bad. There was very little testimony about the bad. We don't really have any testimony about the bad. We think it's a benefit. And then there was nothing put in there other than utilities, et cetera, where there would be debate. But no citizenry stood up and said, hey, this is going to affect me. Rural water has to, sewer has to come from a long way away. Police, fire, et cetera, were real close versus 4 deputies or 6 deputies doing the whole area versus our police department. But again, that's a weighing test. I'm not trying to overturn or tell anybody what to do. Those were all heard in quite detail. So it's our opinion that, again, proper law was applied, and the balancing test, when you look at it, basically they looked at the good to the territory, the bad, the negative to the territory, and if it basically weighed out the correct way, which they found here, the annexation was granted. Thank you for your time.
Thank you very much. And you still have 8.5 minutes.
Thank you, Judge. May it please the court, my name is Gretchen Holderman, and I represent the village of Grafton, one of the appellees in this case. I do concur with the points made by Mr. Taylor, and I would like to highlight some additional points. First, the Lorain County Board of Commissioners, over the course of 2 days, they are the decision-making authority. They took extensive testimony and evidence, and at that hearing, appellants submitted objections and argument, but no evidence that the general good would not be served by this particular annexation.
Well, the burden is on, at the hearing, the burden is on the petitioner, not the appellant in this case. They don't have to present anything.
Yes, Judge, you're correct. As for the maintenance of Durkee Road, this court has made it clear that the point is not to create an issue regarding road maintenance. You don't even need an agreement if there is no issue created, but in fact here, there was a fully negotiated agreement by and between the county and the village of Grafton. This is common. It was executed through the authority of legislation by the village of Grafton, and upon annexation, when when it would be appropriate, the only time would be appropriate, the county was in agreement to also execute that.
So the language of your ordinance is not, it is on approval of the annexation instead of in condition of the annexation, something to that effect. So there's some language in the ordinance that talked about this agreement taking place once the annexation.
Yes, the language is that they will execute this, or they will provide road maintenance. And it doesn't say upon condition of, but I think that the board and the court found that it was in a qualifying road maintenance agreement in any event. I would also submit to your honors that there was testimony by the county to that effect, where Assistant Deputy Engineer Mr. Swick indicated or confirmed that the county did negotiate this particular agreement.
So just to get it straight, prior to the annexation, there was an oral agreement, and that's what Swick testified to at the time, or that there was going to be one?
There actually was a written agreement by the terms of which went back and forth by and between the county. It was only executed by Grafton, and it would be executed after the annexation by the county.
So it wasn't an executed agreement at the
No,
time?
it was only half executed.
Okay.
Yes, but the agreement was, in fact, the written agreement was negotiated between both parties.
And this is the September agreement Attorney Trader was referring to as one of the exhibits.
Yes, it's the one in the record. I believe it's the record at 12. And it was attached to that resolution authorizing its signature, at least by the village. I would also highlight the fact that as part of the annexation process, the law contemplates the desire of the owner, and Mr. Flanagan, who's the principal of K&G, did testify it was his intention and request that the petition be granted. I think that we can't lose sight of the fact, or it can't be overstated, that this development won't happen if the annexation doesn't occur. So it's not a matter of general good of people that wouldn't even be residents, because the cost prohibitive nature of having to install a second unnecessary lift station.
Cost prohibitive to the developer?
Yes, ma'am. Yes.
Was there testimony at the hearing that the owner said, I will not develop if this does not go through?
He said it was cost prohibitive to him. I guess the original lift station was about $250,000, and after so much time it would be expected $300,000 to $400,000, and he said it was cost prohibitive and would then therefore be abandoned. The annexation, Your Honors, would inure to the general good. It would allow the developer to use the lift station that he'd already constructed without further financial burden. It would allow him to complete the fourth of his...
How does it benefit the surrounding half area in the township? This development, I take it, only in the part that's going to Grafton. The surrounding area will not have the new homes in the development. How does it benefit
That's right.
that surrounding half mile?
Thank you, Judge. The addition of 55 new homes into the county is a general good asset to the county and all the areas.
Not the county, that half mile. specifically, how does it help that half mile? I don't doubt that 55 homes will help the county raise their tax base, all of those issues. But that narrow band, I'm gonna call it that half mile around this area, how does it benefit them?
Well, it benefits any businesses located in that area.
Are there businesses located in the area?
I'm not sure, Judge,
Okay.
to be honest. But I think the growth of a residential area helps everyone in the surrounding community. I think addition of people in that area will obviously be communal to anyone living close, and any businesses close, although I don't know if where exactly the businesses or how close they are. I would submit that there's further benefit to the continuity of the original development itself, sharing infrastructure, water, sewer, zoning, police and fire services. I think that it is a little bit, well, I think, like I said, you can't lose sight of the fact that there would be no development if it had not been, or if the annexation is not allowed to go forward.
Does the trial court's decision consider not just the territory to be annexed, but the half mile area or out in the township outside that area? Does the trial court address that?
Your Honor, the trial court specifically said that the weighing of those factors were on the commission, and that as the deciding authority, it felt, it had found that, the Board of Commissioners had found that the general good would be benefited, and he said he did not want to substitute his any fact-finding authority from, take that away from the Board of Commissioners. Sorry, I'm getting a little turnaround. I would ask this court to approve the decision of both the board and the trial court as the administrative appellate body. I think that there was substantial testimony, and indeed Judge Morality found that the commissioners had executed their duties in weighing the evidence and finding that there was a preponderance relative to all 6 factors, and including factors 5 and 6. And I would also want to note that regarding the road maintenance agreement, that notwithstanding whether we had an executed or not executed agreement, there is no issue as between the county and Grafton, because the parties had mutual assent relative to how those things would be handled. So payment towards the road maintenance is sufficient and adequate to qualify as an agreement. And I would also ask, Your Honors, that...
And I'm going to have to ask you to wrap up because you're running out of time.
Okay, I'm sorry. Well, I would submit that I think there was no abuse of discretion, and I think that the law was applied by the court below, appropriately, and I'd ask you to affirm. Thank you.
Thank you. Attorney Schrader, you'll have about 4 minutes for your rebuttal.
Okay, as to that agreement, here's the problem. The legislature wanted these to be a condition of annexation. That gave some assurance to the township, the county, everybody involved, that the road would be properly maintained, there wouldn't be confusion. There is no condition. This thing's never even been signed by the county officials. In fact, for the signature lines, Jerry Ennis retired some time ago, and Lori Kokoski is no longer on the Board of Commissioners. More important, the very last sentence of this agreement says, "The parties shall review this agreement upon any proposal of further annexation of territory along South Turkey Road." That ain't much protection for you. That's not a condition of annexation. It's an agreement that can be reviewed anytime there's another annexation. So again, we believe that the burden of proof was on them. It's de novo because they didn't follow the right statute. It should be at least remanded, if not reversed. As to the general good, I hate to ask you to read that transcript because I did last night and it's no fun. But in it, it's true that the developer said, gee, it's gonna cost me $250,000 to put in a lift station. What he didn't say and begrudgingly admitted it on cross-examination was Lorco had told him, listen, buddy, we'll pay for it. Or we'll let you put it in and we'll reimburse you. Now granted, they were gonna get reimbursed by way of a tap-in fee. And then the argument becomes, well, gee, their tap-in fee's $8,000 and Grafton's only $1,800. Well, now we're talking about a rather speculative thing because this would be the 55 residents that aren't there yet. But there's also testimony in here, and I think it was Mr. Gambita, the gentleman from Lorco. I've gotten these names confused, and I apologize for that. But the gentleman from Lorco said, look, yeah, we charge $8,000 as a tap-in fee, but at some point you paid it and you're done. But if you go, you have to weigh that against the fact that, and this is true in all annexations where a city has an income tax, if you go to Grafton, you're paying about 1.5% of your income to Grafton as an income tax, and that never ends. So if you compare those two, it wasn't the horrible economic situation that the developer made it sound. So it's going to take too long to really go over that, the second part of the general good argument, which is why when you consider on balance, A, they didn't follow the statute because nobody really looked at the effect on the unincorporated area of the township. Neither did the judge. Now normally it'd be a good idea for a trial court to say, I'm deferring to the administrative board. That's the law in Ohio. But that only occurs if the administrative board bothered to follow the law to begin with, and they didn't. There was no serious evidence as to the effect on, positive or negative, on the unincorporated area of the township, let alone a determination that on balance, benefits somehow outweighed detriments.
The commissioners found, as I recall, the only benefit was the property values in that surrounding half mile would go up. Was there testimony to the fact that the property values around that half mile would go up?
I don't believe so. There was testimony that somehow it would create jobs, and there was testimony that we don't know how much, but it might help the schools because there'll be some income tax. I don't remember either from reading the transcript last night or suffering through that hearing on 2 different days. I don't remember anyone saying what Judge Stevenson just suggested. That's going to, the rest of the argument is, you've read the briefs, there's no point in me going over that. So let me save you some time. Unless you have any other questions, I'm going to sit down. Thank you very much.
Thank you very much. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and the Ohio Supreme Court website will also have it, the opinion posted there.